We have a quorum. We're going to get started with our briefing. I'm going to call Will Tilburg up, the Executive Director of our Maryland Medical Cannabis Commission. So Will, why don't you come up and take a seat? One of the reasons we did this was at the hearings a couple weeks ago on the cannabis bills. Among other things, Senator Hershey had raised questions about, the methodology of how we dole out licenses and that kind of thing. And you had indicated at least that perhaps during that hearing there may be some misinformation out there about how things operate. And I thought it would be good ahead of us taking up this issue yet again tomorrow when we've got the House bills. This would be a good time, in a pretty targeted way to maybe address the committee so the committee understands how you operate and how the licenses are issued and that kind of thing. So with that, I'm just going to turn it over to you, and then obviously, there'll be some Q&A potentially. So, Will, just do your thing.
All right.
Okay.
Thank you, Mr. Vice Chair, members of the committee. Again, Will Tilburg on behalf of the Maryland Medical Cannabis Commission. As the Vice Chair stated, there were some questions coming out of the hearings a few weeks ago. And so I'd like to primarily be here today to answer any questions that you may have. In the lead up to that, I thought I'd provide a little background on the most recent licensing round. And as several members were not on the committee at the time, and it's also just been a few long years since it passed. So as background, in 2019, the Commission held a second licensing round for medical cannabis grower and processor licenses. This was the direct result of House Bill 2, the Medical Cannabis Commission Reform Act, that the General Assembly passed as emergency legislation in 2018. That bill did a lot. It was 40 some odd pages, but it had 5 primary pieces that related to licensing that I think are relevant to remind everybody of here today. First, increase the number of growers that are allowed in the state from 15 to 22. It then established a cap of processor licenses at 28. Previously, there had been no limit, so House Bill 2 establishes a new limit of 28, but at that time, 15 had been awarded. And then it did not address dispensaries in any fashion. So the focus here was on growers and processors. 2, it mandated MMCC to award 3 grower licenses and 3 processor licenses to 2015 applicants that had certain qualifications, mainly that they were in just outside the top 15, in that 15 to 30 range, and either had a grower license and were 16 to 30 in processor, or had a processor license and were 16 to 30 in growers. So six licenses were mandated to be issued just by that. So with the increase of 7 growers and 13 processors, we're now down to 4 eligible growers, 10 eligible processors, because there was those mandated awards. Third, MMCC is directed to evaluate a disparity study ordered by the governor to determine whether there's a compelling interest to establish remedial measures in licensing, that is, race-conscious provisions within licensing. Fourth, it reduces the number of commissioners from 16 to 13 and eliminates all commissioners effective October 1st, 2019. So everyone who had been serving to that date is gone. The governor may reappoint up to 5, but everyone had to be reappointed. There's new positions. And then lastly, commission had to conduct extensive education and outreach to small minority and women business owners and entrepreneurs, and issue grants to business development organizations and educational institutions to train small minority and women business owners and entrepreneurs on the medical cannabis industry and the application process. So those were the 5 major requirements for licensing. What then did the commission do? First, it consulted with MDOT, who oversees the state's MBE program, the Office of the Attorney General, and the Governor's Office on Small Women and Minority Businesses, and came out with emergency regulations as directed by the bill to create a new application process, and through that application process allocated 15 points to diversity provisions. So 15 out of 100 points on the application were diversity related now, which had not been previously there in the 2015 round. That at the time was the most comprehensive effort at diversity anywhere in the country, and it was also just the second attempt by a state to expressly include race, gender, ethnicity in the evaluation of cannabis licenses. Second, the commission hosted co-hosted with the Legislative Black Caucus 12 free public workshops for people to come and learn about the medical cannabis industry, about the application process, and ask questions about the forthcoming application. More than 400 potential applicants attended those workshops. Once there was an application posted, we hosted an additional 4 workshops that were open to the public so they could ask specific questions about the application, and had the different pieces of it explained, challenges that folks had experienced the first time around, that sort of thing. That was attended by more than 500 potential applicants. We also awarded $225,000 in grants to different organizations to train small minority and women business owners and entrepreneurs on the medical cannabis industry, how to run a business, how to fill out an application, et cetera. Those trainings were attended by 700 potential applicants. Finally, we posted the draft application on our website for 30 days, said please comment, ask your questions now so we can answer them. We received more than 300 questions, posted the responses to all of those on our website. As a result, we received 109 applications for growers, 104 applications for processors. So that is 213 total applications for a grand total of 4 grower licenses and 10 processor licenses, which means if you were applying for a grower, you had roughly a 3% chance of success. If you were applying for a processor license, you had less than a 10% chance of success. Those applications were reviewed by Morgan State University in conjunction with the commission staff. The evaluation process took about 3 months. Prior to award of any licenses, there were concerns raised to the commission and publicly about there being undue influence or bias by Morgan State in the review process. And so at that time, the commission chair hit the pause button on the review, and the commission issued an RFP to conduct an independent investigation to determine whether there had been any undue influence or bias in the review process. That took about 6 months. The law firm that won that competitive bid created a hotline, 1-800 hotline for applicants that had concerns to call, an email address associated that they could reach out to. They interviewed applicants. They interviewed MMCC staff. They had access to all of our records. They interviewed reviewers and staff at Morgan State. The ultimate conclusion was that there was no undue influence or bias in the application process. As a result, the commission was able to move forward with awards. And so in October of 2020, the commission awarded 3 grower licenses and 8 processor licenses. So 11 total licenses. Of those, all 11 went to disadvantaged minority businesses. 9 of the 11 were Black or African American owned businesses. 5 out of the 11 were majority women owned businesses. So at the time, and still to this day, that is the most successful licensing round anywhere in the country regarding cannabis in terms of percentage of minority and women businesses receiving licenses. Finally, the commission, through that process in 2019, as well as the previous licensing round in 2015, has learned significant lessons about licensing in the cannabis space, the challenges that are presented, and particularly when it comes to incorporating race, gender, and ethnicity, because of the constitutional implications that brings. And so it offers to this committee and the General Assembly any information or assistance it can provide as you evaluate what comes next in terms of adult use legalization. We're members now of a national group of cannabis regulators that are working on developing best practices in areas of licensing and regulation. So happy to share the information we've learned from these other jurisdictions, as well as our learned experiences over the last several years. With that, Mr. Chair, I'm happy to answer any questions the committee may have.
Okay, thank you. I thought that was very, very informative. We're going to start with Senator Augustine, and then we'll go around the horn. Senator Augustine.
Thank you, Vice Chair. I think that was very helpful. Can you share who filed the complaint about the bias that generated the?
So there were statements made to the Baltimore Sun, and we also, at the commission, received a letter from the Legislative Black Caucus that they had heard from constituents certain concerns, and they outlined some of those concerns in a letter.
Okay.
And as a result of that, the
did-
commission paused the process.
Okay, now that's good. And Chair, just one
Sure.
more, this is like here, but it's not. The disparity study, what's the schedule of that, just given where we are with what we're looking at for adult use? What was the schedule in this instance, and in your opinion, could we be asking for a disparity study on adult use right now?
So the disparity study that was performed in 2017 piggybacked off of the Department of Transportation's every 5-year disparity study. And that was in part because at the time there was no cannabis industry within the state to evaluate. So the commission hired a consultant to evaluate that disparity study, looking at certain NAICS codes that were related to cannabis, so agriculture, pharmaceutical manufacturing, retail, those types of things. So because it was based off of a study that already existed, and it was pulling from that data, the turnaround time was relatively quick in a matter of months. So if you were able to do that again, it may not be that long. If you are, as other states now are looking to do, performing a separate disparity study just for cannabis, that requires collecting all of the data from the relevant businesses. And this is contemplated in House Bill 837, which passed out of the House last month, that the commission would be required to collect certain data from medical cannabis licensees on what they've spent money on, who they've contracted with. So that would involve data collection, then having a consultant or somebody else, compile all of that, evaluate it. It could take significantly longer than being able to piggyback off of an existing study.
Okay, thank you, I appreciate it.
Okay, we'll go to Senator Hershey, and then we'll go over to Senator Hayes after that. Senator Hershey.
Thank you, Mr. Chairman.
Oh, are you, I didn't, Senator Klausmeyer and then Senator Hayes. I missed Senator Klaus. Okay, we'll do that. Senator Hershey.
Thank you, Mr. Chairman. Well, you were talking about, let's go back to HB 2 and what we did with those growing licenses and processor licenses. I think you said that there were 7 awarded for growers after the 3 automatic became 4 additional, correct? And of those 4 additional, how many have been awarded?
3.
3. And is there one that's in litigation right now?
It's not in litigation right now. At the same time that the commission awarded those 3 grower licenses, it also denied 3 applicants who may have been in line for the 4th. And while allowing, one of those, of the 3, appealed that decision. And while that administrative process has been playing out, the commission is not awarding that 4th, as they may be successful with their appeal.
So explain that, what that process is as far as, I understand rankings come out through, is it subject matter experts or some additional rankings come out and then there's an audit of applications? Is that, or how does that process work?
The commission contracted with Morgan State University. So Morgan State reviewed 90 of the 100 points on the application. Commission staff reviewed the other 10. Those scores, evaluations, rankings were combined by commission staff and then shared with commission membership along with the evaluations and all of the application materials. So then commissioners went through, reviewed everything, and ultimately determined to adopt the rankings that had been presented to them by Morgan State and commission staff. Based on then the subsequent investigations that occurred. So that's a preliminary ranking.
Preliminary rankings, and they're made public?
They were, yes, they were posted by application number because the entire process was blinded. So
Okay.
the reviewers, MMCC staff, commissioners, nobody knew the identity of the applicants or the owner's employees associated with the application.
Okay, but the applicant knew their application
Yes.
number? So they knew if they were ranked higher or lower?
Correct.
Okay.
So then from there, the commission adopted those rankings. And that didn't award anything, but it authorized commission staff to conduct a preliminary investigation into the accuracy and truthfulness of certain aspects of the application. Now, we were awarding up to 5 points based on race, gender, ethnicity. And initially in those preliminary rankings, it was based off of an attestation of a nameless person because it's been redacted. So in the second phase, that comes back, commission staff can see the identity of the individuals, as well as if they made financial contributions to the applicant entity, had participated in creating the application, other sorts of indicia of ownership. And so initially, commission staff were performing this. When concerns were raised about undue influence and bias, we contracted with a third-party financial firm to complete that review. They then made recommendations to the full commission. Based in part off of those recommendations, the commission awarded the 11 licenses I referenced and denied 9 others. Those 9 other entities that were denied were given the opportunity to appeal through the Office of Administrative Hearings, to which the commission delegated its authority.
So, so 9 had the opportunity to appeal this third-party review, is that?
The commission's ultimate decision to deny the application.
And did the commission take the third-party reviewer's recommendation and just move forward with that? Is that what you were saying?
That's not what I said. I
Okay.
was not privy to those are confidential deliberations that don't involve staff such as myself.
Okay, so these initial rankings are made public. They, by application number. If you know your application number, you know where you fall on that. Then the secondary review comes over. There were some problems with that, so you went to a third party to do these reviews? Is that what you said? Is that where?
To assist with them, yes.
To assist with them. And then they make recommendations back to the commission?
Yes.
Okay, and then does the commission take those recommendations and give out the license based on that?
They reviewed those recommendations. They were part of their ultimate decision. I wasn't part of that decision as I'm not a commissioner.
Okay.
So I can't say specifically.
So they reviewed it, but we don't know if they had to take it directly with what the third party.
That's outside the scope of what I have direct information about.
Okay. All right, so then they came back and the commission makes recommendations based on all of the data that they've received. Then, if you did not get awarded, you have a appeal process?
Correct.
And how does that work?
The denied applicants, the day after the announcement was made in a public meeting, the denied applicants received a letter that outlined their rights in the 30-day period to request an administrative hearing.
That's with the OAH?
Yes.
Okay, and then what happens in that process?
So 6 of the 9 that were denied initially requested such a hearing.
Right.
So the commission then has to enter into an agreement with the Office of Administrative Hearings to delegate authority. At that point, the Office of Administrative Hearings takes over. They conduct all communications from then, schedule hearings. So in each of the ones that requested the hearing, there was a multi-day evidentiary hearing held by OAH. And then the OAH administrative law judge has 45 days after the end of the hearings to make proposed findings of fact and law to the commission. Those proposed findings of fact and law go to each of the parties. Either of the parties then can request an additional final exceptions hearing before the commission. And then within 90 days of that exceptions hearing, the commission issues a final order on the appeal at that juncture.
The commission issues a final order based on OHA?
Yes. So
Recommendation.
they receive proposed
Right.
very comprehensive proposed findings of fact and law from OAH, have this supplemental exceptions hearing with the parties, and then ultimately reviews the case and issues a final order.
Okay. You mentioned that you are not part of the final decision-making process of the applications, but are you deposed in these hearings with OAH?
I did serve as a witness in some of those hearings, yes.
And at what capacity are you a witness then?
In my role as
But I mean,
executive
if you're not part of I thought you said you were not part of the decision-making process on the applications.
The decision-making processes by the commissioners are subject to deliberative privilege, so they're not something that would have been discussed in the hearings. What was going on in the hearings was an evaluation of the application materials presented and whether the commission's findings related to those and the denial was appropriate.
Okay. After the OAH makes a recommendation, the commission adopts that. Does that exhaust the applicant's appeals process? Or is there anything?
They would then be able to bring it to court should they be unsuccessful in the appeal process.
They could bring it to circuit court? Is that what it is?
That's my understanding.
Have any of these reached circuit court appeal yet? Do you know?
No.
So everything that has been a concern from the applicant has been resolved at the OAH level?
The exceptions hearings that I referenced
Right.
have just wrapped in February, and so the commission is currently in the window of drafting the final orders for those cases, and they'll be out in the next couple of weeks, I would imagine.
Okay. And then you said nobody has gone to circuit court?
Initially, there were 6 applicants who requested a hearing. One of them withdrew that request and decided to go directly to circuit court. So that case has been litigated in court.
Oh, so there is one in circuit court? They went directly to circuit court?
They went directly to circuit
They
court.
bypassed the OAH?
Yes.
Okay. And so in both of these processes with the growers, you have, again, by HB 2, as far as growers, there were 4 that were available, 3 have been awarded, 1 is in litigation. So.
One is outstanding.
One is outstanding. You will not issue that license until the appeals process is finished for that applicant?
Yes.
Is that the process? And then is that the same with the processing licenses? There were 8 that were available, or I'm sorry, 8 were awarded and 2 were in, I say litigation, but you say in an appeals process, and they will not be awarded either until that appeals process is finished for both of them?
Yeah, the commissioners have stated until the administrative hearings that process is done and the final orders have been issued, they will be holding back on awarding the final approvals.
And that's still, that the applicant still retains its right to go to circuit court before the commission would act on that license?
I'm not sure.
So we just said again that OAH would make a recommendation to the commission. The commission has decided not to award these last 2 processing licenses while there's concerns that are out there. My question was if OAH comes back and makes a recommendation, but technically an appeals process is still available through the circuit court, has the commission decided that they are not going to award those until that appeal process has been exhausted?
I don't believe that they've addressed that issue, a hypothetical of going beyond the administrative process. What we've afforded to the denied applicants is the administrative hearing. So all that they've stated thus far is that they would wait for that process to complete. I can't say
Okay, when you say
definitively.
wait for that process to complete, you mean the OAH, not necessarily?
Yes, yeah, I don't have one way or the other, a
Okay.
decision after that.
All right, good. All right, I appreciate it. Thank you very much. Thank you,
welcome.
Mr. Chairman.
Okay, we'll go to Senator Hayes, and then we'll come back to Senator Klausmeyer after that. And then we have Senator Eckert here waiting patiently for some bill hearings on.
Gotcha.
Oh, you're part of this group too? Okay, well, Senator Hayes, and we can take as much time as we want.
Cool.
then. We're good.
Thank you, Mr. Chair. And I apologize, I came a little late. Did we get any written material or briefing material for this? This is
No,
all-
I think this was, no, the answer is this was just, I think in response to when we had the hearings, there was, I think Senator Hershey raised some questions, so we thought it would be helpful just to bring Ms. Tilburg in, just to ask some general questions about how they go about doing licenses. You
Yeah.
know, so, no, there isn't anything written.
No, thank you. And it is really helpful to have this briefing, and thank you for coming. I had a couple of questions that I just jotted down quickly. How many awards, one of the things that we kept on hearing during the testimony on the other bills, way to go, Bruce, was the corner on the market where people have both processor and growing licenses. So how many awards have been for both processors and growers?
If I understand correctly,
The
how
same
how
in-
many,
the
how
same-
many current licensees hold both a?
Correct.
Okay. Thought maybe that would come up, so I did. I did not put it in my notes. I will certainly follow up after the hearing to confirm this, but the question's been asked a few times lately,
Yeah.
so my recollection is that 16 out of the 21 growers owner control both a grower and a processor license. And
Gotcha.
then 16 out of 26 of the processors then owner control both of the license categories.
You said 16 out of 26 processors?
Yes,
Own or control?
a grow and a
growers'
processor, yes.
Okay.
So there's 16 entities that hold, in some fashion, through ownership or control, both licenses.
Both
Yeah.
licenses. And of those, how many of them are African American?
I know of at least one, I'm not sure.
Okay. Could you get that information for us?
absolutely.
That would be really, really helpful. And then, from my understanding, there's some applicants that already have pre-approval licenses for processing.
Yes,
And pre-approval is often referred to as like stage one of the approval process, I
Correct.
imagine. And so, how many of them are that, and how long is the typical waiting period, or how long have these applicants been waiting since the pre-approval?
so the pre-approval is what the commission awards based off of the merit of the application, so that's your application score. From then, the entity has to go find a location, complete a build-out, the security, the equipment, et cetera, and then receive a final inspection from the commission. And if the facility meets all of the requirements, they can receive that final license. So of those 26 processor awards that I referenced, there are currently 7, I think, that remain in the pre-approval stage, and so there's 19 that are licensed.
So about 7, I just said pending because it's an easy
Yeah.
word to identify. So 7 of them are pending after
Yeah,
pre-approval.
and so all of those were the awards from October of 2020.
Okay. And is that typical, is that a typical waiting period between getting pre-approval? Or what is the typical?
It varies pretty significantly. If you look at the first 15 processors, there were several that were up and running and licensed and operational within about 16 months. But there were several that took two years or longer. The more recent awardees have had the added challenges of the pandemic, which has impacted, the ability to get local approval for zoning, has impacted ability to get capital in some instances, and can have other impacts that have delayed their ability to get up and running. But the timeline so far isn't out of the norm compared to what we saw in the first licensing round.
Right, so you bring up an interesting point around zoning. So part of the criteria by which you would pre-approve someone isn't predicated on what the local zoning is. It's other factors that you consider to pre-approve someone?
The pre-approval is issued based off of the score on the application, which is, how you're gonna grow or process the plant, your security plan, your business plan, your business history, and then in the latest round, the diversity of the business. So
Gotcha.
it doesn't include,
It doesn't include zoning. So you could actually go through all of that, spend some money on all of these consultants or whatever, but the local zoning might prohibit you from operating.
and so with that in mind, in this second round, the commission did not require a location at the application stage. So businesses, they were asked to put down where they think they will be located, but they're not held to that. They have the ability to site elsewhere if it is, easier for them to get up and running.
Got you. And so that includes the, I think you said, like 7 or so that's been pre-approved already for our
Yes,
process.
correct.
Got you. All right, and then on the grower front, how many pre-approved do you have, and what's that typical
3.
waiting period? There's 3 of them. And the typical waiting period for that? Was that also in October round?
Also from October 2020, the first time around, about half of the awardees were up and running within 16 months, and then most of the rest came in the next 6 months or so after. So it's somewhere between, a year and a half to 2 years most typically.
Got you. And the last question, Mr. Chair, and thank you so very much. So out of this almost a dozen probably growers and processors that are in purgatory, how many of them are African American?
That is, so when I referenced the 11 awards, 9 out of 11 are African-American firms, so
Those are the ones that are in pending status?
Yes.
Okay. And that's processors or growers? I'm sorry, I missed
That's, 2 of the 3 growers are African-American, and they are currently in the pre-approval stage. And 7 of the 8 processors.
that. Got you. Thank you, Mr. Chair.
Okay, Senator Klausmeyer.
Yeah, thank you. I'm just going to go back all the way to the very beginning, okay? What year was that, do you remember?
I wasn't here, but 2015 was, when you say the beginning, the initial licensing?
Yes,
Okay, the initial application was the fall of 2015. The initial awards were the following summer and fall.
okay. Now, and at that point, we were told that each senator district got 2
That's
dispensaries, is that right? That's what I was told then.
The commission regulations lay out up to 2 dispensaries for each senatorial district. In
Right.
addition, in the statute, the General Assembly created a separate category of grower dispensary, allowing licensed growers to have dispensaries. And so they are not subject to that 2 per legislative district
So I could
regulation.
have 5 if there's licensed growers and all?
Within your district?
Yeah,
There's no district that has 5.
no, but I mean, if those people got the licenses to grow and everything.
The commission evaluates change of location requests, and part of that is the number of businesses that would be located in a jurisdiction. So I can't say for sure whether they would allow 5, they have allowed 4 within a district.
And this may sound like a crazy question, but I know I have 1, but I don't know if I have 2, if there's any way you could find that out for me.
Yeah, I'd be happy to share that after the
And
hearing.
it was tough going back at the very beginning, and I have to say this because all of a sudden, it landed in the neighborhood, and I had no answers, I had nothing going about it, and that's the way it's always been. I feel like the only way I'm going to go is just to keep calling you and say, did anything happen today or anything, so. But are you doing anything to help those people who can't get their licenses or, dispensaries? I mean, does your group do anything, your
So
commission?
for dispensaries, there are, I think, 5 that are outstanding still from the initial award in 2016. 3 of those are related to ownership litigation.
Ah,
The commission can't do anything with those. The other 2 outstanding have had issues in terms of local zoning, which is beyond the authority of the commission. I personally have testified in front of county councils in support of the businesses,
Okay.
and will offer any information that I can to the local governments to assist in their review of the process.
Okay. Well, I hate to have asked those basic questions, but you don't remember because you weren't here. It was never in our committee to begin with, and all of a sudden it was thrown in here, so. But thank you for your answers. I appreciate it.
Okay, so I see
welcome.
2 lights back again. So why don't we'll go back to Senator Hayes, and then we'll close up with Senator Hershey, and then we'll go to the bill hearings, I think is the way. So Senator Hayes, we'll go back to you, and then we'll close with Senator Hershey.
Thank you, Mr. Chair. And I think my colleague, Senator Klausmeyer, bring up, some good points without having to legislate notification. I think for all of us, it would be helpful if we receive some type of communication about what's going on and what impact it might have on our district. So if you would take that message back to the commission, I think it would be helpful for all of us. But in our contemplation of adult use, there's been a lot of talk or references to the issue around equity and the fact that, you know, some that have both growers and processors, and that's why I asked those questions, kind of have like a corner on the market or monopoly. Has the commission contemplated any ideas or regulations around, you know, trying to eliminate or, I guess, trying to overcome some of those barriers where people may not feel like they get a fair shot? And so what's being proposed now is like these micro growers, because people feel like there's not an opportunity to, you know, participate. Have there been any consideration or contemplation around how do we create greater equity in the market?
It's something that the commission evaluates and considers constantly, has conversations with our regulator colleagues across the country. It's something that a lot of states are facing challenges with. How do we increase equity? How do we assist the businesses that are more diverse, that do have licenses? But in terms of the current medical program and what the commission can do, we don't have the ability to issue any more licenses. House Bill 2 prevents the commission from even telling you if we think there should be additional licenses. Not until 2024 are we able to submit a report on whether the demand is such that additional licenses would be necessary. And so our hands are very much tied when it comes to trying to further facilitate equity in the industry, because there's no licenses that we have the ability to award.
Got it. Restricted to 2024. I'm sorry. And I did have another question, and now it's kind of escaping me. The equity piece. Gotcha. I'll leave it there.
And
Go ahead.
you had asked about providing information to you,
Right.
to other members when something is impacting your district. I'm absolutely going to follow up, but if you have a sense of what type of, you know, a new business opening in there, we don't really have those. So what would be helpful to share with membership about the businesses or what's happening in your district?
Right. I thought you had alluded to that you all know where the address in which they've indicated that they like to locate.
Oh, for the new awards, yes.
Right.
So if they cite within your district, providing you that
Right.
information. Okay, absolutely.
Yeah, because I think what, you know, Senator Klausmeyer said is, you know, she has one, she knows she has one, she don't know if she has two, but even with the one, she probably wasn't even notified ahead of, once you guys decided to go ahead and certify that. And I guess for me, you know, it would definitely be helpful to know, you know, where they're located. Because oftentimes, when the community have questions about how this came about, we're usually the first person they call, and then it starts us on the path of trying to find out what happened and how that, you know, took place. So,
That's very helpful, Senator. Thank you.
gotcha.
Okay, good suggestion there. Oh,
Yeah.
yeah, did you?
No, I think I'm done. Thank
Okay,
you.
so let's close it up with Senator Hershey, because he's the guy that started the idea for the briefing to begin with, and then we'll go to the bill hearing. So Senator Hershey.
Thank you, Mr. Chairman. I'm going to follow up on what Senator Hayes was asking about with respect to the final grower's license that's available. That is a minority applicant that has applied and had been recommended for that and went to OAH. Is that correct?
I'm not sure that I,
So there's one more license that's available for
there,
growers.
yes, and
right?
there's one grower applicant who was denied
Right.
that appealed that decision.
And appealed that decision. That decision went to OAH. OAH ruled favorably for that applicant.
Correct.
What's now the process on that being awarded? For
The-
that's a minority applicant, correct?
Yes, stated
Yeah.
ownership was
Right.
majority, minority-owned,
Right.
African-American-owned.
Right.
Following the proposed findings of fact and law, there was an exceptions hearing that was
Beginning-
held by the commission. It's part of those then final orders that are forthcoming. So from the exceptions hearing, Department of Health regulations require a final decision within 90 days.
Right.
And so I would anticipate that, in particular, that decision would be forthcoming here in the next couple of weeks.
Okay, appreciate that. Thank you very much.
Okay, guys, well, thank you, Will, for coming in. I
Thank
think
you.
that was actually very informative. So that's going to conclude the briefing, and obviously, Mr. Tilburg's available for any follow-up, questions on this important, timely topic. With that said, we're going to now go to Senator Eckert. She's got two bills, and we're only doing sponsor only, so these should go pretty quickly. We're going to start with Senate Bill 994. Senator Eckert, you can take as much time as you need to explain the bill, and then we'll go to your next bill, which is 1004, but we'll start with 994.
Thank you very much, Mr. Chairman and members of the committee. That was fascinating discussion, since I do have a medical cannabis grow operation and kind of have a little in my district, and I know a little bit about how they got there and what they plan to do, so this has been helpful. I am here today on 994. Senator Addie Eckert, for the record, and members of the committee, this bill actually came to me in the middle of the night. With true confession here, as you know, I've been on the Behavioral Health Advisory Committee. I've worked in mental health and psych work for probably 40-plus years, and have been also have been on the Lieutenant Governor's Behavioral Health and Addiction Commission as well. And we have struggled regularly with listening to family members and others come in to say, ask for an outpatient commitment. I think many of you are probably familiar with that. And we were trying to determine how we get access to care early on when somebody who has a serious and persistent mental illness begins to decompensate. And I go back to a number of years ago when I brought a bill in that would do an outpatient commitment, and essentially it came from one of the patients I was working with who had severe schizophrenia, and he asked me one time, why can't I write down what medicines work for me and where I need to go for treatment if I do certain behaviors, like run through the street naked, get threatening, am not able to care for my own personal needs. Can you please get me the medication that settles me down and take me to the hospital to see Dr. Wise? We brought that bill before the committee, and actually we got a kind of an outpatient commitment if you had been treated in one of the state psychiatric facilities. Fast forward, that was in 1995. And fast forward, we've struggled with this for years. Probably, I think it's been about 8 years ago, we passed a bill, again on that same theme, that was called an advanced directive for mental health advanced directive, which essentially does that. It puts an individual's treatment plan, the medications they're on, the medications that work when in a crisis, and it should be available in some kind of a database. So when folks were pushing to see if we would introduce legislation on an outpatient commitment, I got to thinking, well, we have a mental health advanced directive. Why aren't these being used? Because if you were a first responder, if you were a primary care physician who was treating somebody who had severe and persistent mental illness, all you have to do is call up that plan of care, and you would be able to see what medications work. And probably, if a person had been off their medications for a period of time, just begin to reintroduce that medication instead of having to go through, you know, a full evaluation and kind of that sorting out what works and what doesn't work, but you'd already have that plan of care. And that's something we who've treated folks for years have been using. Well, what I found out when I asked about this is that we do have mental health advanced directives, but they're not readily available, and I don't believe they're readily used. So I met with the Department of Behavioral Health, Dr. Jones, and asked about this and said, would this be a way of getting access to care at the right time in the right place so that we don't have this continued wanting to hospitalize people or do an outpatient commitment, which gets resisted regularly. So I bring this bill to you, and my thought is this, and I think it's supported by folks in the mental health, behavioral health community as well, that if in fact we could do a campaign, an educational campaign on the use of the mental health advanced directives, and then if we could figure out a way to embed them in CRISP, they would be readily available and be able to then access that information to get that treatment in a timely manner. I also serve and have worked very closely because the community behavioral health system developed while I was working in inpatient services at Eastern Shore Hospital Center. So I know how they evolved and stay connected to those outpatient, delivery systems. And in fact, that was one of the issues that was reinforced by a number of those programs, saying if we could get that embedded in CRISP, that would be really helpful, because then when folks have even an acute psychiatric crisis or decompensate, we could get that early intervention ahead of time because if folks are off medication for a longer period of time, it is harder to get folks back and either calmed down or stabilized. The longer individuals go without their psychiatric medication, the harder it is to then be able to get the behaviors under control and to live a more normalized life. I know the letter in here from Ben Steffen indicated something different. I'll be glad to have a conversation with him. But if we could get this first step with the education campaign and begin to get folks to agree to this, I think the next step would be getting it in a place where our first responders could use this and we could prevent further deterioration and maybe even suicide in many cases. Thank you very much. I urge your favorable consideration of this. It came late because we had a hard time getting it drafted over in bill drafting.
Okay, thank you,
So
Senator
thank you very
Eckert.
much.
Thank you for testimony. Any questions for sponsor, Senator Eckert? Okay, seeing none, we're going to go to your next bill, Senator Eckert. We're on 1004, Senate Bill 1004.
Thank you very much, and you've probably heard this many times before. This bill has been brought in by, Mr. Chairman, Madam Chairman, Mr. Vice Chair, and members of the committee. Senator Adi Eckert, for the record, here on testimony for Senate Bill 1004. Under current law, there's not a standardized cost component allowable for prescriptions that are managed by several pharmacy benefit managers. Community pharmacies across the state are experiencing a downward trend in the cost calculation used by the managed care industry, which is based on an effective rate that does not coincide with the actual cost of the medication. This has made it so that many of our small local pharmacies are yielding a net loss for supplying medications. They are required to fill at the prescription at a loss. Senate Bill 104 would prohibit pharmacy benefit managers from reimbursing a pharmacy or a pharmacist for a prescription drug or pharmacy service in an amount less than the national average drug acquisition cost at the time the drug is administered or dispensed, plus 10% of that cost. If that national average drug acquisition cost is not available at the time a drug is administered or dispensed, a PBM may not reimburse in an amount that is less than the wholesale acquisition cost of the drug. The insurance commissioner may require that a PBM pay a fee to be determined by the commissioner in addition to the minimum reimbursement required, and adopt regulations to carry out the bill that include a process for periodic reviewing and recalculating of the minimal reimbursement amount. And again, this comes late. You're probably not going to do a lot with it this year, I understand, but please know, if you get a chance, go back to any of your local pharmacies and go and see if they will have you look at their records, and you will see the disparity in cost. It is staggering. And most of the pharmacists have to hire additional people to be able to calculate these costs and track every single one of the medications that go out. And they are struggling to stay alive and stay afloat. And I would say that our community pharmacies are essential and vital because they're there for individuals when nobody else is. And I would ask your favorable consideration and of this, if not this year, we'll look at it next year, or maybe even consider some kind of discussion through the interim once we get through elections.
Okay, well,
Thank you very much.
Well,
But
thank
it is a serious issue in our rural areas.
well, thank you for your testimony. Any questions for Senator Eckert? Seeing none, that concludes the bill hearing on Senate Bill 1004. Next, we'll go to Senator Klausmeyer, Senate Bill 984.
Thank you, Madam Chair, Vice Chair, and Committee. Senate Bill 984, Public Health State Designated Exchange Health Data Utility. The State Designated Health Information Exchange, HIE, CRISP, is connected with hospitals, physicians, practices, skilled nursing facilities, payers, care managers, and public health agencies. The HIE was established in 2009 and spent the first 10 years focused primarily on sharing information with providers to improve the health and wellness of their patients. Senate Bill 984 will expand critical opportunities for the health information exchange to reduce provider burden and increase data exchange to improve quality of care. There are three main parts of Senate Bill 984. Number one, the bill formalizes a state-designated health information exchange as a health data utility. It is important to note that this does not force public health agencies to use the HIE. The bill just makes it clear that CRISP is an available resource for interventions and reporting related to public health and health equity. Number two, the bill requires dispensers to share prescription drug information with the HIE. Many other providers are either mandated or volunteer to send data to the HIE, including dispensers for controlled substances, keeping track of full medication sets so that can help improve equity and access, as well as to help avoid negative drug interactions. The bill will shore up long-term consideration for the HIE, including consumer input, privacy protections, and financial sustainability. Many groups reviewed the intent and language of this bill. While there is broad support for the concept, there are some recommended changes to the text which would clarify the data use and further protect consumers. The House has voted in favor of the House cross-filed with the reference amendments. I have requested the amendments to be drafted for this bill to be put in as for the same posture. I thank the committee for their consideration of Senate Bill 984 and am requesting a favorable report. The Executive Director of CRIS, Craig Bem, is with us in the audience today to help me answer any questions anyone may have.
Okay, thank you, Senator Klausmeyer. Any questions for Senator Klausmeyer on Senate Bill 984? Okay, seeing none, thank you. That concludes bill hearing on 984. We're going to next
Thank
move
you.
to Senator Kramer on Senate Bill 948. Senator Kramer. And while you're doing that, I'll just acknowledge my district mate, Delegate Dave Fraser Hidalgo, who is, I think, the crossfile of this legislation. Welcome to the Senate Finance Committee, Delegate Fraser Hidalgo. Okay, Senator Kramer.
Isn't it nice to see Delegate Fraser Hidalgo visiting us here? Look at that happy face. What's not to like? Good afternoon, colleagues. Ben Kramer introducing Senate Bill 948. This is an important bill. I'm disappointed that it didn't get scheduled until the day after crossover because it is important. And we know that by virtue of the fact crossover has happened, we know that should the committee pass the bill, it will rest in rules over in the House. The good news is the House bill, sponsored by Delegate Fraser Hidalgo, is already out of the House in the same posture as the bill before you and sitting in this committee. And I hope that the committee will unequivocally and quickly pass it, and so that we are enacting this good legislation. Also disappointing is the fact there are a lot of people who know a lot about this bill, and they're not in a position to testify and share that knowledge with the committee today. So you're going to have to, unfortunately, rely on me exclusively in the presentation of the bill and to hopefully answer any questions you may have. But once again, perhaps when Delegate Fraser Hidalgo introduces the bill for the House bill, he will have that opportunity to allow the supporters of the bill to speak to the committee and shed even greater insights as to the purpose of the legislation. The bill will create a pilot program to electrify our public school buses. Why is that important? Well, let's take a look first on the environmental side of the issue. Diesel school buses generate about 27 tons of CO2 per year. That is six times that of an average car. They also produce nitrogen oxide. A major constituent of diesel exhaust is the nitrogen oxide, and it contributes to acid rain and all kinds of other environmental harm. We are accustomed to seeing diesel buses because that's what's been in use for decades. But we are now finally at a point where technology has taken the role of the school bus and afforded us the opportunity now to start electrifying our school buses. But it's not just the environment that is a concern. Of equal, if not greater concern, are the health consequences of the damage that diesel buses do. Asthma in our children here in the state of Maryland is, and it was interesting because just this afternoon, I went to the Maryland Department of Health's website to take a look at the issue of asthma in our children here in Maryland. It is significant, and it is unquestionably exacerbated by diesel fumes. In 2018, asthma-related hospitalizations in Maryland cost $28 billion. $28 billion in health care costs. More importantly, and strikingly of concern to every member of this committee, is that the Department of Health has on their website a graph that shows among Black, non-Hispanic children, asthma is 5 times that as white non-Hispanics. We have a problem with asthma in our children broadly and specifically in our minority communities. Why might that be? Well, I guarantee you diesel bus plays a factor in that. When diesel buses are sitting on urban roads in traffic, bellowing and belching diesel fumes and smoke and exhaust into the cabin of the school buses with our children sitting there sucking it up hour after hour as the school bus makes its route. In rural communities, children sitting in those school buses with leaky exhaust filtering up through the school buses into the cabin, again, breathing for hours the exhaust of the diesel fuel. It has a significant impact on their health and their well-being, and particularly asthma. And in fact, as early as it is in the process of school bus electrification, studies are already indicating that zero-emission buses are making a significant difference in reducing health concerns with children, and in particular, those with asthma. The bill before you will, for the first time, allow boards of education to work cooperatively with our public utilities to create a pilot program. And what that pilot program will do is afford the schools to buy the buses, and the utilities will help set up the necessary infrastructure, help them provide the electrification, so that as we are moving forward, and folks, we just passed a very ambitious bill on the environment. This is an important step in ensuring that we actually can accomplish the goals of that bill, because we need to start studying and understanding how we're going to do this. What are the demands on the grid? What is it that can be done and perhaps can't be done? That's what this pilot program will do. It will start to establish an understanding of how we're going to work with the electrification of our school buses. And the school buses, when brought to scale, will provide our electric utilities with a significant amount of electrical storage. As part of the bill, when the school buses are not in use, our utility companies will be able to draw the electricity stored in those batteries if that electricity is needed on the grid. So envision in the middle of the summer when these school buses are sitting in parking lots and peak demand is on the grid because of the need for air conditioning, and we're talking peak rates when there's peak demand. Now our utilities will be able to access all that stored electricity in these buses and pull that up onto the grid, saving taxpayers money and saving having to fire up the coal and gas-fired power plants. The bill has pages and pages and pages of support testimony, and I hope you'll take a look at that, particularly because no one was permitted to testify with regard to the bill. There is no opposition to this bill. It passed overwhelmingly from the House. Finally, committee, I would proffer to you that we have already passed language in Senate Bill 528 that says this can be done. The problem is, this is the bill that provides the framework for doing it. Right now, we don't have that framework, but it's already been established when we passed the Climate Solutions Act that this can happen, but there are no boundaries and no framework whatsoever. This is the framework, this is the bill we need to pass to complement the Climate Solutions Bill and ensure that we are, A, looking out for our environment, and B, looking out for the health of our children who stand at the schools at the same height as those tailpipes of those diesel buses, sucking in the diesel fumes. Our teachers standing there, loading the kids at the buses when school is over, sucking in the diesel fumes. Our bus drivers exposed to those fumes. We need to move this bill. Thank you, colleagues. If anyone has any questions, I certainly welcome the opportunity to at least try to give you an answer.
Okay, thank you, Senator Kramer. Any questions for the sponsor? Senator Kramer, Senator Hershey.
Thank you, Mr. Chairman. Senator, the bill references $50 million in rebates. Can you discuss that and who's rebating who and where that $50 million comes from?
The utilities will provide a rebate to the school systems. And that rebate, and it will ultimately be finalized by, all of this is governed by the Public Service Commission, and the parameters of the rebate will also be, but the rebate in general terms will reflect the difference between the school system purchasing electric buses, zero emissions buses, and the cost of a diesel bus.
Right, so the fiscal note says that a electric bus could be about $340,000, a diesel bus being about $90,000, $250,000 difference. So would that mean that a school system could buy 200 buses and the electric company, the public utility, will reimburse the school system that $50 million?
Well, first of all, and I don't know where the fiscal note came up with its value, but the Maryland Department of the Environment submitted to the committee a letter, and the letter indicates that based on little pilot programs that they have been running, that the MDE is seeing an increment cost of approximately $250,000 for an electric school bus.
Right, that's what I said.
So there is a difference there, but to your point, is that depending on what the program is that is established, and again, there's an application process that will go to the Public Service Commission for the utilities and the school system as to how great a program, the extent, the size, how large. And yes, the difference being that the electric utilities will provide the rebate to help the school systems purchase the buses, and in exchange, the utility companies will have access to all that battery storage when they need to have it, and there's no charge for them to access all that storage.
Okay, so it's an exchange then. For the $50 million, the
Well,
electric.
the 50, just real fast, I don't mean to cut you off. The 50 million is the maximum
Right.
that this program can have. It
Okay.
may not come anywhere close to that, but there's a cap here.
Okay, so for the up to $50 million that the public utility invests in the school system for the differential of the buses, they would then gain access to the battery storage that those buses have in the summertime.
Or at any other time, but yeah, I was pointing out in particular when that demand might be really helpful. Could be, look, on inclement weather days when it could be a bitter cold day and there's snow on the ground and those buses are sitting there because schools are closed, then people are going to be running their heat. And that may also be a time that the utilities may find it appropriate to access that stored energy. that
Okay,
stored electric.
so in the times when those buses are not being utilized, which I would agree would probably be mostly the summertime, and then some additional dates when school is not in session or not in. Do we have any idea how many homes a school bus can electrify? Or, what are we talking about quantity-wise? The battery that are in a school bus, again, when we say that that's the exchange for the up to $50 million, is there any idea what one school bus can electrify as far as residential
I
units?
don't have an answer to that question. There would have been a gentleman who I think would have had the answer to that question that could have testified to that. And again, based on the scale of when we do start really electrifying school systems, their buses, that scale is actually relatively significant.
Okay.
It is actually very meaningful, the accumulated storage.
All right, two more questions. So this up to $50 million is in exchange for being able to utilize the battery storage. This is not a cost that gets passed on to ratepayers, correct?
With regard, again, the Public Service Commission will determine if there are some of the costs that may or may not be part of a rate schedule. This whole program will be in the hands of the Public Service Commission. They will take a look at the costs of accessing, for the utilities to access that stored electric, and that'll be for the Public Service Commission and it'll be done on each individual basis.
Each individual school system that does this.
Correct.
So, you again spoke about the investor-owned utilities, which the bill references. Can the co-op electric companies participate in this as well, too?
That's an excellent question, and I don't have the answer, but pause for one moment. Oh, Delegate Fraser, there he is.
Oh, there you
May I ask, let's see if the House sponsor do you have an answer to that?
Yeah, it's pretty written, pretty wide open.
Okay. Okay,
Here,
And
why don't we
David, I can
ju-
talk-
We don't want to create any precedent here, so why don't we,
Yep,
why don't we
I
just,
got it.
offline,
I didn't see it back there
that's,
anymore.
pretend that didn't happen, because.
Pretend that didn't happen.
Okay, back to you, Senator Crane.
We gotta be flexible, Mr. Chair,
Yes,
gotta be
I got you.
flexible.
I got you. We don't,
I think that was all of my questions. Thank you.
okay. Any additional questions for Senator
Thank you for
Kramer?
the questions.
Senator Kramer?
Great questions.
Yeah, a lot of good questions. Seeing none, that concludes the bill hearing on Senate Bill 948, and the final bill hearing.
Thank you, Mr. Chair.
For today is Senator Benson, Senate Bill 955, Senator Benson. And then we'll do voting on a couple bills, a couple little bills. Senator Benson, you take the time you need to present Senate Bill 955.
Thank you. Good afternoon, Madam Chair, Mr. Vice Chair, members of the committee. Senate Bill 955 is designed to establish that professional personnel and staff employed by the Maryland School for the Deaf are in the professional and skilled services of the state personnel management system. This would allow these employees of the Maryland School for the Deaf to have equity in their pay negotiations. Also, it would require that the Secretary of Budget and Management assign the experienced personnel and staff to the professional and skilled services of the state personnel management system, certain bargaining units, and require that the professional personnel and staff of the school suffer no diminution of pay or benefits. This overall is a correction of previous legislation. Remember, we passed legislation in 2021 that provided collective bargaining for the faculty at the Maryland School for the Deaf. So, this overall is a correction of previous legislation that left out certain groups. Passing this bill is a matter of doing what is right for those who work diligently with children who are disabled. Therefore, I ask that you give Senate Bill 955 a favorable report.
Okay,
Thank you.
Thank you, Senator Benson. Any questions for Senator Benson on Senate Bill 955? Okay, seeing none, that concludes the bill hearing on Senate Bill 955 and concludes our bill hearings for today. Madam Chair, I'll yield back to you for, we've got some votes.
Thank you. We've got two. I know.
All right, the Senate Finance Committee is now in a voting session, and we're going to start with Senate Bill 23. Senator Carter. Kathy.
Said do that first one, because I don't care if I vote on this one.
They are saying they got to do it the other way around for some reason. I don't care.
Okay, Senate
But
Bill
you want us to
23.
announce that you want to- you favor
This bill requires the Maryland Department of Transportation, before announcing or proposing any major service change under certain federal standards, to conduct a transit equity analysis, perform a cost-benefit analysis, consult with members and leaders of affected communities, and take certain actions based on the results of these activities. MDOT must also perform these analyses and consult with affected community members and leaders before announcing any reduction or cancellation of a capital expansion project in the CTP that exceeds certain thresholds. The bill also expands existing transportation plans, reports, and committees to include transportation equity issues. Before you is a reprint that has amendments that have been drafted to align with amendments that were adopted by the House. And so I can just quickly walk.
I'll move favorable on the bill as amended.
Yeah, so this is the bill that, that requires certain information to be included in the Transportation Goal Attainment Report. Amendments push back the requirement for the inclusion of this information by 1 year. There are additional members that are added to the advisory committee that provides information on this report, to include a representative of the Maryland State Conference of the NAACP and a representative of a transportation labor organization designated by the Maryland State and District of Columbia AFL-CIO. There's some additional information that's to be considered when considering the impact of transportation investment. You have to consider the impact on racial equity and, to the extent data is available, persons with disabilities. If you go to page, I guess page 8 of 15 of the reprint, this bill, as introduced, would have established the Commission on Transportation Equity, but the House amendments strike the requirement that this commission be established, and instead there's a requirement that MTA develop transit equity analysis policies and guidelines, including thresholds for when a reduction or cancellation of a capital expansion project in the CTP requires analysis. And then beginning in fiscal year 2024, this is where I described that before announcing a major service change, the Department of Transportation has to conduct a transit equity analysis that includes certain information. This is on page 13 of 15, they have to perform a cost-benefit analysis that includes an analysis of impacts on economic development, employment, education, health, and environmental justice. They also have to consult with members and leaders of affected communities that include certain communities, including senior riders. And if a transit equity analysis reveals disparate impact or disproportionate burden, MTA must develop alternatives that would meet the goals of the proposed service change and conduct a transit equity analysis on the alternatives. If a disparate impact can't be avoided through one of these alternatives analyzed, MTA has to proceed with the alternative as the, if a disparate impact can be avoided through the use of one of the alternatives, they have to proceed with that alternative as the primary proposed service change. If there's no alternative that would avoid a disparate impact, MTA may not implement the proposed service change unless there's a substantial justification that exists that necessitates that change, and must implement the alternative that causes the least disparate impact or disproportionate burden. So before holding a public hearing on the proposed change, MTA must publish on its website for the routes or lines impacted by the service change an evaluation on the demographics of riders and the service area. And after completing the public hearings, the MTA has to publish the analysis and cost-benefit analysis on their website, as well as compile a report of the impacts that includes certain items that are listed here.
Senator Hershey?
Thank you very much. Is there a difference between an advisory committee and a commission? That's what it changed from, right? It was a commission and it went to an advisory committee?
So the commission has been struck.
Right.
There is an existing committee right now, and what the bill does is it adds new responsibilities for the responsibility of the advisory committee that provides input on the annual transportation goals.
Okay. And that committee can make recommendations to reduce or cancel projects? Was that what I heard?
So this is the advisory committee makes recommendations to the Department of Transportation on the annual attainment goals for the CTP.
Okay, so not on specific projects. Okay, but then you said that they could provide impact or input on service changes, right?
So there's a requirement that, under the bill, there's a requirement that this transit equity analysis be done. as well as a cost-benefit analysis. And then there's a public input process.
So let's say a business that decided to locate in Maryland and there wasn't a specific transportation route that got there, and they needed to make a change to get citizens, employees to that location. That change in route would have to go through this entire process in order to be approved?
If it's a major service change, then this is when the process would apply. They'd have to do these analyses.
And does this analysis consider, see, it does a lot of different things. Does it consider economic development and employment?
Yes, it does, I believe.
Page 15.
Let me go to the
15.
Yeah, so on 13, you know, there are certain elements that have to be considered in doing this analysis, and that would include impacts on economic development, employment, education, health.
Okay. And just, again, the committees, their role in all of this is, again, to just advise, or is it, is there any weight to this advisory committee, or is it just a recommendation and the MTA can follow it or not follow it?
So again, that specific, you know, the bill as introduced would have created this Commission on Transportation Equity, and the House struck that element of the bill out of it.
Okay, so now
The
it's
creation
just,
of this commission.
now it's just advisory.
So it's these, so, yes, we have the existing advisory committee relating to the CTP process, and then we have these additional analyses that have to be done before major service change is implemented.
Okay, thank you,
Senator,
Patrick.
Thank you, Madam Chair. I just wanted to follow up on Senator Hershey's question, Patrick. From my understanding, there's already an existing advisory board with certain powers. The bill, when it was presented to us, was to, in addition to the advisory board that already exists, to create a whole nother commission, and the House struck that entire whole new commission. It's just adding 2 members. All right, got
Correct,
it.
that's exactly
All
right.
right, also, so in the so the changes in the existing advisory board, they add 2 people, and I want to, Senator Augustine, I look to him as kind of his expertise in the transportation field. I see that they added the state conference of the NAACP, so I get where they're trying to go, but for the most part, from my understanding, the state conference is a volunteer organization that may or may not have the capacity or whatever. Are there other organizations that have expertise in looking at equity in this regard? And I'm trying to kind of look into my colleague across the room to see if there's any other. But I guess the question for you, Patrick, first before Senator Augustine answer that, do we know, based off of the testimony or anything from the House, if the state council has indicated any type of expertise in this area?
I don't know if we know that from the testimony. I mean, you can see on page 4 that the membership of the advisory committee already has a number of other
Yep.
representatives.
I get it.
Including some folks who have expertise on transportation.
Yeah, my hypothesis is that the addition of the NAACP representative was to represent the African-American experience as it relates to equity, right? That's what I think they were trying to get at. My question is, have we identified the right organization? I'm not sure of the answer to that. Senator Augustine, are you aware of any organizations that may fit that bill?
I am not, but I'm happy to talk to you about it and try to figure out, you know what I'm saying?
Yep,
Yeah.
absolutely. It's a volunteer organization. And oftentimes, when you need to do an analysis and have There's nothing wrong with NAACP. It's a great organization. Right, in this capacity, I just concerned, is it just a seat filler, or do they have the capacity to have input in a substantive way to the industry? Right? And I'm not sure of that. I'm not sure what the answer to that is.
I think the goal would be to have those people who are in the community and understand a particularly affected community.
Right.
That would be, that they might have that connection to the communities to be able to reflect, okay, we're talking about cutting off service here, and they would have that grassroots understanding of the impact.
Absolutely, and they may or may not. I'm just not familiar. Being familiar with the organization, not sure if they have the capacity. It looked like Madam Chair was going to get us some.
Senator Augustine, you have something else to add?
No, I just wanted to, I mean, I can echo, we have to go and look a little bit, but there are definitely organizations that are more targeted in the space that we could probably look at. I think that that's true.
Do you want, between the two of you, if there's unreadiness to vote because you don't have the information you need, you want to hold this for the next voting session while you check?
Yeah, that's a tough one.
I mean, otherwise, it's before us now, we've got the opportunity to vote.
I would say, yeah, I agree. I'm gonna take the advice of my colleague over here to my right. We don't want to slow the bill down, but Madam Chair, I would like the opportunity to see if there's other information out there that could help better inform it. I get totally, what they're trying to do.
Reword it.
Yep.
You may want to reword and take out the NAACP. You may, but you want to keep something there now.
Yeah.
But we can't go on and
So,
on
yeah,
and on with
let's
these what
let
ifs.
the bill proceed, and then we'll check back with you, Madam Chair, in the meantime, if something comes up on the floor.
So are you asking to hold the bill
No,
to the next
just
voting
let it go.
session?
Let's vote
Or
on it.
let it go?
Yes,
All
ma'am.
right, in that case,
We've got a motion and
Oh.
a second.
okay, all in favor, please raise your hand. Okay, it's not unanimous, so let's call the roll.
What is this? On the bill?
Yeah. Okay.
Senate Bill 23, favorable with amendments. Senator Feldman?
Aye.
Aye. Senator Klausmeyer?
Yes.
Yes. Senator Benson?
Yes.
Yes. Senator Kramer?
Yes.
Yes. Senator Hayes?
Yes.
Yes. Senator Reedy?
No.
No. Senator Augustine?
Yes.
Yes. Senator Beidle? Yes. Senator Hershey?
No, but very quickly, I just,
No.
There, I
we
think
just-
I think there's some unintended consequences with this bill.
But right now, we're just trying to
Okay.
finish taking the vote. Okay.
Senator Jennings?
no.
No. Madam Chair?
Yes,
Yes. Bill passes.
okay. All right, so the bill passes.
Okay, so Senate Bill 890, you should have a reprint so reprint that, we've got some amendments that the chair is offering, the sponsor, that would align the Senate bill to amendments that the House has adopted in the cross file. So I can explain the bill and walk through the amendments. So Senate Bill 890 requires the establishment of an abortion care clinical training program. This would be an abortion care clinical training program in the Maryland Department of Health. The purpose of the program is to protect access to abortion care by ensuring that there are a sufficient number of health professionals to provide abortion care. The department must contract with a coordinating entity to administer the program, and the department must use funds appropriated in the budget for the program to contract with the coordinating organization. This organization must have demonstrated experience in coordinating abortion care training programs at community-based and hospital-based provider sites, be a nonprofit entity, be in good standing in any state or jurisdiction in which the organization is registered or incorporated, submit an annual report to MDH on the performance of the program, and meet any other requirements established by the department if the requirements are not inconsistent with Title 20, Subtitle 2, which is the statutory provisions that relating to the protection of the right to abortion care services. And then this organization will perform the following functions, which is on page 4 of the reprint. It would administer grants to develop and sustain abortion care training programs at a minimum of 2 community-based provider sites, administer grants if funding is available to other, and administer grants if funding is available to other community-based sites, hospital-based provider sites, continuing education programs, and establish training program requirements that are consistent with evidence-based training standards, comply with any applicable state law and regulations. And then an amendment here that the House accepted was, and also focus on the provision of culturally congruent care and include implicit bias training. The aim of the the program is to expand the number of healthcare professionals with abortion care training and increase the racial and ethnic diversity among healthcare professionals with abortion care training. And then the coordinating entity would also support the identification, screening, and placement of qualified providers at training sites. The department must release the name of this organization that the department contracts with and any entity receiving funds through the coordination organization. The department may not release the name of any individual or person administering services through or participating in the program. On page 5 of the reprint, there's the mandated appropriation. In each fiscal year, the governor must include in the annual budget bill an appropriation of $3.5 million for the program. This next section, 134406, establishes a fund for the program, the Abortion Care Clinical Training Program Fund, which has the purpose of supporting the program. The health department must administer it. We have some additional language that we see that's standard in statutory provisions that establish funds. The fund may only be used for the program, and the comptroller pays out money from the fund as directed by the secretary. No part of it may revert or be credited to the general fund or any other special fund in the state. And expenditures from the fund may be made only in accordance with the state budget. This next section, 134407, requires the department to submit an annual report on the program each year to the governor and to the General Assembly. This next part of the bill on page 6 relates to the Medicaid program, and this provision requires the Medicaid program to provide coverage of abortion care services to program recipients in the manner that's described in the insurance article. This is, and we can look at those provisions in a second, but this is consistent with the protected right to abortion care services under state law, and also to provide in providing information to consumers using the terminology abortion care when describing coverage. That's the cross-reference to these insurance provisions. The next section below updates provisions relating to consent and minors. Terminology is updated to refer to a qualified provider, because the bill would be expanding the ability, expanding authorization to additional provider types, advanced practice clinicians, And so that term is being substituted for physician and all of the provisions relating to minor consent. In the bill as introduced, there were provisions that would have modified what qualifies as conclusive evidence, that notice was provided to a parent or guardian. And the amendments have struck those provisions and retained the requirements in current law with respect to having documentation that the notice was provided. And on page 8 of the reprint, moving to section 2207, this is the section that deals with who may perform an abortion. And as stated here under 2208, it's currently the case that an abortion must be performed by a licensed physician. What the bill does is that it allows a qualified provider to perform an abortion. So this would mean an individual who is licensed, certified, or otherwise authorized by law to practice in the state, and for whom the performance of an abortion is within the scope of the individual's license or certification. So these would be, advanced practice clinicians like nurse practitioners or physician's assistants, certified nurse midwives. These types of professionals would be authorized under state law to provide abortion services. The section below is the current law section that prohibits the state from interfering with the decision to terminate a pregnancy, and these provisions are updated to align with the changes that would now allow a qualified provider to provide these services. On page 9 of the reprint, we have some new requirements relating to insurance coverage. This section of the bill establishes abortion care coverage requirements on insurance carriers. There are exceptions for multi-state plans that do not provide coverage for abortions in accordance with federal law, as well as high deductible plans with health savings accounts, and they're excluded from the coverage requirements. These plans are subject to some limitations on being able to provide coverage without a deductible under federal law, and some of the coverage requirements in the bill would require coverage of these services without cost sharing, and I'll explain that in a second. So those plans are excluded from the requirements. And then third, there is a religious exception, so that an organization would be eligible to obtain an exclusion from the coverage requirements of the bill. They can obtain this exclusion from a carrier if the coverage requirements conflict with the organization's bona fide religious beliefs and practices. And so we have a provision like this in current law right now with respect to contraception coverage, and a similar exclusion is included in the bill here. So what this is it requires a carrier to cover abortion care services without, this is on page 10, without a deductible, co-insurance, co-payment, or other cost-sharing requirement, and without restrictions that are inconsistent with the protected rights under statute. Carriers also need to provide information to consumers about abortion care coverage using the terminology abortion care to describe coverage. If the insurance commissioner determines that enforcement of this section may adversely affect the allocation of federal funds to the state, the commissioner has the ability to grant an exemption to the requirements to the minimum extent necessary to ensure the continued receipt of federal funds.
Madam Chair, can I just
Yeah,
ask?
sure.
So, give me an example, I mean, I obviously know at the federal level, we've got Hyde Amendment and restriction. Give me an example of when federal fund, there'd be federal fund implications, under that particular provision you just read, just.
Yeah, so I don't think, I'm not sure what circumstances that, that might occur. I mean, I think the way that it is now, that there are no federal dollars that would be going to provide coverage for abortion care services. I think more than anything, this is just a savings clause, so that if there were something that maybe changed at the federal level, that the commissioner have the ability to change the requirements.
And you said you're going to go back to what, this idea of a multi-state plan is not covered here. Give me an example of, do we have multi-state plans here in Maryland? I mean,
So we actually, so there are no multi-state plans that provide coverage through our exchanges right now. But what the ACA requires is that one of two multi-state plans offered in the exchange, one of two may not cover abortions. And so that's why there's this exception here for a multi-state plan. But it is the case that right now, we don't have any multi-state plans that are offering their plans in our marketplace.
What would that mean in terms of trying to have adequate capacity in Maryland?
In terms of, in what regard?
In terms of abortion, if you've got plans in Maryland that don't cover it all.
So, I mean, I think it's the case that most plans right now do cover abortion care services, and because because we don't have any plans right now that constitute a multi-state plan that's subject to this exception, I don't think there'd be any significant impact.
Yeah, Senator Reedy?
Were you done going through the bill?
Not yet. Okay. So I think we left off at page 10 of the bill. So as you all know, we have a state-based young adult health insurance subsidies pilot program. And this is the insurance 31122. And so there's a provision in here that aims to fix a coverage glitch relating to this state-based young adult health insurance subsidies program. The bill would require the exchange to adopt regulations to provide a subsidy to cover 100% of the cost of the premium for young adults who have a 0% expected contribution under subsidy eligibility parameters under this subsidy program. So it's the case right now that because of federal law and the Hyde Amendment, carriers, when they because no federal dollars can be used towards abortion coverage, they have to collect a separate premium for that and then segregate those collected funds in a separate account and pay for those services independently. And so this is what carriers do. They take out like a fairly de minimis premium amount of, maybe $1 a month. This is, roughly what it is. So in the circumstance where an individual may enroll in this subsidy program and not have any cost sharing obligation because of the subsidies and premium tax credits, it still may be the case that they would be assessed this $1 charge, which potentially can be an obstacle when somebody would more readily enroll when they have no financial, they have no premium out-of-pocket sort of costs that they would need to pay. So the aim of this is to provide a mechanism so that, that de minimis premium amount would be covered to facilitate more seamless enrollment and continuity of coverage in these plans for individuals who have no obligation, no expected contribution for the plan that they're in.
Let me ask this. What do we have here that would help, let's say, a 12-year-old rape victim who's not insured?
I mean, I think that, someone who's 12 years old would probably not be carrying coverage on their own. They would be a dependent enrolled in an insurance plan. So, the potential protection would be that a plan offered, to, their parent or legal guardian, in which they're dependent would have to provide coverage for abortion care services. So the question is how, so I don't know if that's an answer to your question, but it would be an obligation on whatever health plan, would cover those services, that they would have to provide abortion care coverage. Setting aside any exceptions that may be provided. I guess the last thing is that we have a provision here that is sort of on page 12, that's standard language that we include in bills when establishing a fund. There's a requirement that the exchange convene a work group to improve transparency and accessibility of consumer information about abortion care coverage, and then submit a report on their recommendations. And then there's a reporting requirement on the insurance administration to collect data from plans about these segregated accounts and supply this information in a report to Senate Finance and the House Health and Government Operations Committee for certain time periods. And then on page 13 of the bill, the exchange must study extending this last dollar coverage to other enrollees, in addition to the enrollees who received last dollar coverage through the Young Adult Premium Subsidies Program. And then this amendment language would just specify that the requirements relating to insurance coverage would be applicable to all plans issued, delivered, or renewed in the state beginning in January 2023.
Okay, are there further questions? Senator Reedy?
Thank you, Madam Chair. So a couple of questions looking through this reprint. Number one, we just had an extensive debate on paid leave, on paid time off, and we declined to put the private sector at all in charge of any of that, at least as of yet. But this bill basically outsources this whole program to an unnamed, undesignated nonprofit. Since it sounds like the sponsors and supporters of the bill feel this is a crisis that must be mitigated, why are we taking it away from sort of our auspices and putting it with an unnamed nonprofit? What's the rationale there?
What we want is to be sure that people have access. And we expect that we know we don't have sufficient numbers of providers here in Maryland.
Do we know that?
Yeah, you know it, given what's happening nationwide, people are already starting to have to travel across state lines and sometimes 2 or 3 states to get to where they can even have an abortion. And I'm concerned especially about things like young kids who are victims of incest and rape and that kind of.
I know you're concerned about those people, Madam Chair, and I understand, and I just share the concern of people who are victims of rape and incest. I think the question that I have, and I don't know if counsel or someone can provide, is when we decided we wanted to expand health insurance access, we set up a state exchange. When we decided we want to do paid time off, we're setting up a complicated and expensive state entity to do that. So I don't know if, and I'm not trying to put our counsel on the spot because their job is to answer questions about the bill, but this is outsourcing this. Is it fair to say, right? It's outsourcing it to an outside group?
Yeah, I mean, I think there was testimony indicating that there's some organizations that provide this training now, and so I think the thought here was is to, you know, have an RFP process and have this training done by entities that do it.
Training, I can understand outsourcing training. We do that all the time, but this actually talks about administering the program too.
I should clarify that I think that there was testimony that there are organizations that do the coordinating function.
You said there's gonna be an RFP. Is that in here? Does that have to be in law for it to be or is that an assumption? I know enough about procurement to be dangerous, but does it have to have is there an RFP, a public RFP process for this?
Yeah, I don't think that there needs to specifically be a reference to an RFP process.
For that to occur, that's a given. I'm just gonna check on that. Moving ahead in the bill, this bill is really, in my view, not really, whatever you think about the whole issue of abortion or access or whether abortion should be legal in some cases or not or whatever, this bill is pretty radical in that it's basically expanding who can perform what is often complicated and invasive medical procedures, like abortions, especially at certain level of term. So we're basically, I was looking to see if there were any changes from the House, so basically this is unchanged. This is allowing, and the list is here, we're going to qualified provider. This is allowing for like nurse midwives, certified midwives, a physician's assistant could perform abortions under this bill?
In the states, it's within their scope of practice. It's just that when we passed our abortion bill in Maryland 40-some years ago, we left it just with the physicians. We did what we could do to get the bill passed at the time. Actually, many of these other practitioners are delivering babies, they are dealing with miscarriages, they're dealing with all kinds of things that are related. They just right now, because of what we did when the original bill was passed, weren't included.
Well, in Health General Article, Section 20-207, the state law says only a physician licensed by the state to practice medicine in the state may provide abortion services, which you just mentioned, that was passed a long time ago. Shouldn't we be fixing that part of the code? Does this bill fix that part of the code?
Be fixed right here in this part of the code when this becomes a part of the code. And remember that when you consider what was done then and what's done now, many abortions now, especially when they're done early, are just done with pills. Yeah, and there's no reason that somebody who's able to deliver the child and to give you the service for a 9-month period of pregnancy and then to do a delivery couldn't give you the pill if you are just finding out that there is in fact a fetus in you.
I understand that, Madam Chair, and again, though that isn't, so we're going to let other people prescribe medicine now too, it sounds like under the bill, if it's for performing abortion. That's a separate issue, but.
They would have to get the necessary training to show that their scope of practice should be expanded to do it. In many cases, they are doing even more so right now.
Okay, but putting aside the pills, if I could ask counsel, basically physicians are trained to perform surgeries. This would open this up for anybody to perform surgeries on someone as late as 9 months pregnancy to perform an abortion, correct?
So I think these advanced practice clinicians would still be subject to the scope of practice limitations that they have under statute, under the health occupations article, and the standards of practice established by the health occupations boards and on all the ethical guidelines that govern the provision of care.
So this bill does change 20-207 to where it'll change that law as well? I didn't see it, I was looking through.
So the bill 2207 is on page 8.
Okay.
And so what this is dealing with is a very specific restriction in statute with respect to the provision of abortions, so that it would no longer be limited to licensed physicians, but would include these qualified providers for whom the performance of an abortion is within the scope of the individual's license or certification. So if an abortion is something that can be performed within the scope of their license or certification is granted by the Board of Nursing under statute and is within their training and their skill level and their competence, then they would be able to perform the service. But this particular change here is in the statute that is specific to the legal restriction in providing an abortion in health general.
Okay, and then the last question that I have about this, at least for the time being, is the chair, our chair argued, talks about that there are people already crossing state lines to get abortions. We don't have any data on that, correct? Is there any data collected on that?
It's really happening. Where do you think people can go when you get states doing crazy things that are going on now and just cutting off
Well,
all
Mississippi's
service?
one. Do we have data that shows that a lot of women from Mississippi are traveling? I'm sure anecdotally there are some, but do we know how much the demand is and what success looks like relative to how much capacity we need?
Law changes that became more reactionary from a year ago till now.
I would argue this bill is pretty reactionary too, but I'll stop for now.
Hershey?
Yeah, thank you, Madam Chair. Just a question, is the term abortion care defined in this bill? Doesn't really seem like those two words go together, but is it defined here?
Well, whenever you go to a healthcare practitioner for care, you're getting care. You're getting advice and procedures to deal with the healthcare issue that you have.
Okay, so it's being referred to like in healthcare. Although healthcare, we usually think more of maintaining or restoring
Well, for
of
some
physical
people it is.
well-being.
I think I told you guys on the floor about when I kept a child so that the mother, who was a fellow graduate student with me at Purdue, and her husband could be driven. They had to leave Indiana and go to New York, and in her case, she would have died, and so would the fetus. The fetus was in the fallopian tube. It wasn't in the uterus. And because of the state of Indiana's law at that time, and because a lot of surrounding states were like that, and we not that many places you could go, and you needed it fast, death would have been imminent.
Right.
Okay.
I don't know, that particular case, I would imagine the standard hospital could.
No.
The hospital wouldn't take care of that?
What would have happened is she would have died, and they would have said how great she was. She was a martyr or something. But she
Interesting.
wouldn't be alive, and the child that I took care of while I drove to New York to get the abortion
Right.
wouldn't have had a parent.
And so, Madam Chair, you mentioned, so part of this, does this bill specifically allow individuals from out of state to come to Maryland for abortions?
They don't have to allow. We cross state lines all the time for all kinds of things.
Right.
A lot of us with our Maryland insurance go to somebody maybe in West Virginia if you're near that line, or DC or
Right.
Pennsylvania, sure.
But this won't, but Maryland won't charge co-payments or anything like that here? It'd be free, basically?
This isn't about how you pay. This is about having the right to.
I thought I saw something in here that talked about co-payments and things of that nature. Can I go back to what a qualified provider is? Is that a higher standard or a lower standard of a licensed physician?
In many states, people within their scope of practice right now do abortions that are recognized as being within their scope of practice by state law. It was that simply 40-some years ago when we passed our law, we made limitations that were necessary just to get the base bill passed.
Right,
And
right.
they have remained all these years. And as long as more and more states opened up and abortion services were available, people could get them in other places. And
Right.
there were more practitioners elsewhere.
Okay,
Some
but-
people are probably crossing the line from Maryland now.
And
to get
maybe
them,
that's-
let's say in DC or get them somewhere else.
Right, that's because Maryland has a requirement that they're licensed physicians, so I think that's a
But
higher.
it's got nothing to do with the scope of practice for
It does
people
not.
in that occupation, the training they have. And if
Mm-hmm.
any of the close by practitioners that are mentioned in the bill need to get it, that's what they would do, is have to get the training so that they could also do it.
Okay,
because it's
it
within
just,
the
it
normal
just
scope of practice.
seems if there's a concern for the health of the woman as well too, as you mentioned in your story, that we would want to have that highest level
It's not
of
gonna
provider.
be done by somebody whose scope of practice wouldn't include it. And there are people doing them in all the other states that have it right now that aren't necessarily physicians.
So, okay, so we're changing that standard on who can provide it. And I assume that means that standard of who can provide it it's certified then, not licensed? Is that what you're saying?
I'm saying, when you pass the bill, anybody who is the training already, or who can add to the training so that their scope of practice would make them eligible to do it, would be able to do it. It's only a legal prohibition now. It isn't so much that there are other types of practitioners who have the education to do it and maybe the practical training to do it.
Okay,
So-
and that's what I didn't understand, Madam Chair. I didn't know, for instance, if like a surgeon is licensed to do something, or are they just considered qualified? It would seem that qualified is a much lesser standard. I'd rather go to a licensed surgeon, if that's the terminology that we need, rather than somebody that's qualified. No?
Well,
Okay. I'm just,
using one term rather than a synonym makes you
yeah,
feel better.
I'm just wondering why we're changing it in this piece of
The point is
legislation.
that right now, there are many people in the healthcare occupations who have the training already to do it. And if they were just in a state that recognized it, they would be doing it here. And some of them do them in other nearby states. They don't do it here, not because of lack of training, and that it's outside their scope of practice. It is simply a legal prohibition in Maryland, except we took at the time, 40-some years ago, what we could get.
Right. Looks like now we're trying to get a little bit more.
we should.
There's some things that are very uncomfortable about this, but I appreciate your
Okay,
response, Madam
Senator
Chair.
Reedy.
If there's people here that can do it, if we just change the scope of practice law here. This is a major change for the state. I think it's important to point that out. You may say, hey, other people, they can do it in other states. It's not every other state, some other states. But this is a major change. If we just need to change that scope of practice law, why do we need $3.5 million a year spent on this? Every year, taxpayer dollars.
We probably do have some practitioners here in related fields of practice who, because they've been practicing many years and not doing them if they work solely within Maryland, who do need a refresher course.
Well, yeah, but why, I mean, so fine, that's part of their job, like they go get continuing education. If we
Well,
have,
that's what the bill allows, that
when
they
we have
can
a
get-
problem getting people into affordable housing, we tell realtors, you need to add that into understanding of better placements for affordable housing and the affordable housing market into your continuing education credits. So why, I mean, I don't
But
understand why
we're
we have
not
to pay for
asking
it.
the state of Maryland to pay for the people's additional education so that their scope of practice.
Well, then what's the
clearly
$3.5
meets
million
the needs.
for?
You are organizing a way of offering a major service that is broader than the offerings available in the state of Maryland now, so that you can meet the needs of Marylanders and of others who get their health care in Maryland.
I think there's a lot of unanswered questions in this bill, but,
Are there further questions?
Move favorable with Kelly amendment.
Right, we got a motion, can we get a second?
Have we adopted the amendments? You're adopting.
Can you second?
Second.
Okay, we got a motion and a second. All right, is there further discussion on the motion? Yes.
I've got some amendments that I'd like to walk through with the committee, and it's not going to be 2 minutes. So we can spend some time working on the bill offline, and we can hold the
No,
bill
we'd
till the
like
next
to
voting
move this
session.
bill today.
All right,
We-
all right. Then I'd like to, first, I have an amendment I'd like to offer. The first amendment I'd like to offer is, it's not necessarily in order in your packet, the way
One second, point of order. Patrick, the amendments that Senator Reedy have drafted, are they amendments to this or to the original bill?
They are amendments to the original bill.
Got it, okay, good.
but they can be adapted to fit the reprint, correct?
Yes.
Because obviously I didn't have the reprint to draw
Right.
the amendments to. Yeah, thank you, thank you. So the first amendment I have is the chairwoman mentioned, has talked about part of the need to do this is, because all these people are gonna start coming or have already started coming to our state for abortion. I've challenged that we don't really know that. We know anecdotally, of course, people come into Maryland, but we don't know how many people it is. We don't know what the demand is. We don't know what the supply is. Because there are no stats kept on abortion in our state. So, First Amendment that I have, that I'd like to offer to the bill, and I think it actually strengthens the bill, which, to my chagrin, because I really don't like the bill, but it strengthens the bill. It's 433-529-1, and it would add, I don't know if maybe it's council 433-529-1, but it would allow us to collect de-identified data regarding abortions performed in Maryland. We'd get a sense for each abortion of the age of the fetus, the time of the abortion, and the type of procedure performed, because again, we talk where there's a difference between pills and surgeries.
Well, who would be getting this data? This is people's private health care information.
Well, you would not be private, it would be disaggregated, de-identified, it'd be the Department of Health. And we would be able to understand what's the
Well,
racial and economic
Let's go back, I'm
demographic.
just trying to understand.
Sure.
If I went to get any medical procedure from a medical provider who's acting within their scope of practice in Maryland, how is what I had done within somebody's scope of practice in Maryland, and which is legal, going to end up in a state database so that somebody else can see what is happening? It should not.
Well, I would say that we do keep disaggregated data on a whole lot of procedures in the state. I don't know if I'm wrong, if council could help me with answering that question. We keep de-identified or disaggregated is maybe not the right word. We keep data on heart surgeries in the state, correct?
You wouldn't know it by the numbers of people and what the names of the people were.
No,
who
it's
either
not
did the
names.
surgery or the patients that received it.
Yeah, no, of course. Of course I would never say you should have names. It says it's,
Well, somebody's got to
May I
enter it
ask
into the
council if
database,
they'd
which
like to
means
take a better stab at the amendment?
that you don't have the privacy you should have as a patient dealing with a medical provider in Maryland.
you absolutely should have privacy. We keep statistics on
Well,
how
then
many,
how-
on hypertension and on COVID and on vaccinations. So I would move the amendment,
Okay,
because you can't know if you have a problem if you don't have good data.
okay, well, let's vote on the proposed amendment. All in favor, please raise your hand. Okay, those opposed, please raise your hand. All right, that amendment fails.
I think another huge issue that we should talk about is the overall issue of allowing non-physicians, and we're not just talking about nurse practitioners, they're one group that have a lot of training, but we're talking about midwives who do a great job being midwives, but we're gonna offer them to be able to perform abortion surgeries, physician's assistants, and any other individual who is licensed, certified, or otherwise authorized by law to practice in the state for whom the performance of an abortion is within the scope of the individual's license and certification. The amendment I want to offer would just limit this to physicians, but I do have a question that I'd like answered, and I forgot to ask it when I was asking questions, is who is these other people, licensed, certified, or otherwise authorized? Because the bill spells out nurse practitioner, nurse midwife, licensed, certified midwife, physician assistant. Then it goes into this any other individual. So do we have a list of who that would be?
Well, for now, it'd be those
Well,
specified, and unless in Maryland we pass something later, or the Board of Physicians determine later that because of changes in medical practice, that there's somebody else we don't know of. I mean, a century from now.
Well, this
it could
seems to
be a
indicate-
computer.
This seems to indicate who is licensed, certified, or otherwise authorized by law. So who is that? Can I get it? Yeah.
Yes, I mean, that would be anyone who has been licensed, certified, or authorized by law to, and for whom the performance of abortion is within the scope of the individual's license or certification. So, individuals who have that within their scope of practice would be established by their health occupation board, and their training would dictate that. So that's why we would have, nurse practitioners who have a certification as a nurse practitioner or a certified nurse midwife.
But they're in the bill. I mean, I'm trying to figure out, is there, who else are we wrapping? Because scope of practice, I know from the other committee, they have huge fights over scope of practice. So we're saying the Health Occupation Board, will they come back and have to get a law passed to let, podiatrists perform abortions or something? Or is that can just be done by
No,
fiat because of this bill?
It might be that there will be in the future a health occupation that doesn't even exist as an occupation now.
Oh, I'm sure there will be. It'll
but
be
will
abortionists for
applicable.
sure.
So
There'll be-
right now, the ones that are named are what you know of.
Okay, is that correct?
Yeah, I mean, I think, they have to have authorization and statute, and they have to have approval by their board.
So if somebody right now is not in this list, then they've probably not been licensed yet, but it could be something that happens later, but it would have to be an act of the General Assembly, correct?
I think it just works like any other medical practice works. You have your statutes that govern the scope of practice for profession. So for example, like in the statute that governs nurses, or nurse practitioners, they have specific authority to dispense or to prescribe, and so that's in statute. And we all know
And in
about.
some cases, they have to be under a doctor, right?
We all know,
Other times
like
they
for the
don't.
physician assistant, and so, we have the statutory framework that dictates the scope of practice in the health occupations article. And then the professional boards themselves set the standards of practice that govern the professions. And so all of these it would work just like any other, healthcare service. It would be determined based on their training, based on what's authorized under the scope of practice within statute, and is dictated by their health occupations board and their certification that they get, through their profession.
Okay, but the key point is that language you're telling me does not authorize some group that we don't know about yet to just all of a sudden be able to do it, correct?
No, I mean, I think that's right. So, I mean, like a podiatrist wouldn't be able to perform,
Well, I would hope not.
an abortion because that's not within their
remove your
scope of
wisdom
practice
teeth.
or training or
Right.
competency.
Okay, so it's still to me problematic, the people listed in the bill, but I was glad to get some clarification on the other point. So my amendment would just remove everybody but physicians. It would say, let's keep it to physicians only that perform this kind of surgery. So that's what my amendment would be. I've got it.
Well, you are
I move
trying,
the amendment.
okay, let's,
Is there a second to my amendment?
okay. All in favor of that amendment, please raise your hand.
To add
Yeah.
to supporting that amendment, because I think some of what we just said might not necessarily be accurate. We listed a number of different, not even sure what the providers, could be a physician, could be a nurse, could be a nurse midwife, a licensed certified midwife, a physician's assistant, or any other individual. And then it just says who's licensed in the state, or can perform an abortion within the scope of the individual's license or certification. So now we've lowered the standard all the way down to somebody that just can get some type of certification.
No, it's not some kind. You would have to have an occupational health board who has that scope
I'm
of practice and would be willing to certify that person to see that they're licensed to do it in Maryland.
I think that it's just very concerning for the health of both the woman and the baby if we have lowered this standard so much just so we can bring more providers into this field.
I don't think that is what we're doing.
Well, that's the purpose of
That's what
this
the bill is.
change, is to bring more people in that can provide this
You want
service.
adequate capacity to deal with all kinds of health problems and conditions in Maryland. if you didn't have enough dentists and people were needing to go out of state because they've got an inflamed,
We don't have enough dentists.
molar and they end up with an infection, you need more practitioners who could do that.
Right, but we're not taking podiatrists and saying, okay,
we're
why
not
don't
gonna
you
do it
work on
for
someone's
this
molar? Well, it just says you have to be certified. That's-
Within the scope of practice for the procedure that you're talking about.
Well,
It very well could end up that certain,
It just says that-
abortions that are done fairly early would be, could be done by somebody with a lesser scope of practice than those that are done midterm or later.
I think it's very open. It just says an individual who is licensed, certified, or otherwise authorized by law to practice. That's very, very
Well,
broad.
that's all we've got for everything.
Right,
The
right, so that's what I'm saying,
people that
this-
do work in that field are licensed and authorized
Right.
within their scope of practice to do the procedures that we allow them to do.
Right,
And it's
so-
going to do the same thing. We have artificially limited where abortion was concerned because it was done 40-some years ago
Well-
when,
I think the important part that I think the senator's amendment wants to
you're
to
right,
state
Senator.
is that we want to make sure that this is performed by a physician, somebody that we can trust that can
Well, that's not
provide
the only
this.
person that would have it within their scope of practice. But let's vote on the motion that is before us. Senator Reed's motion, and I think you seconded it. All in favor of the motion? What is- Okay. Well,
Just a question. Earlier you were saying about number of providers. Are you saying we do not have enough providers right now?
that is a major concern that we don't.
It's a concern, but it's not fact right now.
Yeah, well, I mean.
And you were talking about people leaving other jurisdictions, traveling state lines.
That is happening, and it's gonna
But my
happen
question
more
is
so
it happening-
given.
Is it happening because of providers or because of new state laws that are outlawing
Well,
it?
we are aware
Therefore, they're having
because
to
of new
cross state
state
laws.
laws that there is definitely a
So-
problem. And we
So
didn't
this
have enough
amendment is
first.
good. I mean, we're not saying there's a shortage. People are crossing state lines because of state laws. That's not an issue of number of providers here in the state, so keeping it the way it is by a licensed physician isn't gonna cause that issue of people
Well,
crossing state
there
lines
are
here.
people in states that are in close proximity who live in one state, work in another, get their health care maybe in a third state. Yes, Senator.
Been a little reluctant waiting, but I would just make this factoid statement that 70% of our counties have not a single provider. So
Yeah, that
there is
is true.
2/3 to 70% of Montgomery counties, Maryland state counties have zilch, zero. So for what it's worth, I want to throw that fact in.
That is important. Okay, but let's vote on the bill that is, the amendment that is before us, the one that Senator Reedy has put forward and it was seconded over here. All in favor of that amendment, raise your hands. All right. Okay, all opposed to that amendment, please raise your hands. Okay, the amendment dies.
Madam Chair, I have, I think, one more amendment here that I'd like to discuss with the committee. I think it would improve the bill. I asked some questions earlier. I asked some questions earlier. It's actually amendment number 1 in your amendment packet. It's the first amendment listed on your packet. So I asked some questions earlier about how we're outsourcing. Sounds like some people believe this is a critical problem and that we've got to address this shortage of access to abortionists. And so we think it's so important that the government's going to take our hands off of it and hand it to an outside group, $3.5 million a year. So I think, and it sounds like, it's not in the bill, but it sounds like there'll be an RFP process. One of the things I think we need to be sure that we do, we've had a lot of discussions about equity and about historic racism in this state, and there's clearly a history of it. No one can deny it. I would like to put in an amendment, it'd be on page 3 after line 20, that just says that this organization, this nonprofit entity, it says it has to be demonstrate experience in coordinating abortion training programs at community-based hospital sites, be a nonprofit entity, be good standing submit an annual report to the department about the program, and meet some other requirements as established by the department. I want to insert that it should have no history of promoting an ideology of eugenics, racism, or ableism. Just because I think we should be very careful that we not hand taxpayer money to any group that has a foundation in abortion that was based on the idea that certain people were less fit than others. So I think that's a great amendment that we can all embrace, and I would move the amendment, Madam Chair.
Do you think that there are practitioners in Maryland that, in any field at all, that embrace those ideas?
I'm not saying they do now, but I'm reading from one of them that tends to be involved in a lot of these discussions, and on their own page, they acknowledge that their history is one of common cause in the 1920s with white supremacists, and their founder was a big believer in eugenics.
Well, since there's nothing in this bill forcing anybody to do anything based on somebody else's philosophy, it seems totally inappropriate.
Madam Chair, I'm not sure we have a motion.
I make a motion.
Favorable.
All right.
I move the amendment.
We have a, all right.
Well, Madam Chair, I actually think we've done we've worked on a lot of
All right,
issues
we're
where
just-
we're trying to get at structural
I thought I
racism
heard
and the history of
Senator Kramer
racism.
actually make a motion. I didn't hear it seconded yet. Hayes seconded it. And that was unfavorable on this motion.
I'm still discussing it, so I had the floor. But I don't know what that,
The chair ruled.
I don't know what that means. Does that, is you're gonna move unfavorable on the amendment? Is that what the motion means?
Yeah.
Well, that's fine. We can vote it one or the other. It still means you're voting whether you want to keep an organization that has a history and past of racism, embrace of eugenics, and ableism. Should we make sure that we don't give $3.5 million of state taxpayer funds to an organization that has that kind of history year after year? So that's what my amendment does. If you want to vote unfavorable, that's fine, but I think that's a bad idea. I would add that to the bill. So
Okay.
we can go ahead and have a roll call, Madam Chair, if you'd like.
Oh, okay, let's be sure we know what we're voting on. You made a motion, it hadn't been seconded.
I think it had been seconded.
Who said? There was no motion.
Still discussing
But we don't know what the it is because you never made one, and as you continue to discuss your generalized idea, then a motion was made unfavorable.
He was specifically explaining this amendment that's before us.
Right, I'm looking right at it.
All right, well, let's move back. And so what is your motion?
I would like to move the amendment to strike, to make sure that we don't give $3.5 million taxpayer dollars to any organization in this statute that has a history of promoting an ideology of eugenics, racism, or ableism. That should be an easy amendment. We could adopt that by
All
voice vote.
right, all in favor of Senator Rita's motion? Raise your hand. Okay. All opposed, please raise your hand. All right, so that motion dies.
Now, you did have a motion, Madam Chair,
Okay.
on the bill, the underlying bill,
As amended.
if we're ready to call the vote on that.
All right, now, all right, so now we're ready to vote on,
Madam Chair, could I just say that we have the identical bill, House bill, so it would be good that we, with this vote, would also count for the exact same postured crossfile, HB 937, if that's okay with you, Madam Chair.
all right.
I'd like to amend my motion to make sure that the vote on Senate Bill, hold on, I was moving too fast, my apologies. Senate Bill 890 with the Kelly amendments are reflective of the House crossfile.
Okay, do we have a second?
Here, just-
Make sure I understand that. We're just saying that this bill, with your amendments, is the same as the House bill, but we're not voting on the House bill.
Well, I was proposing that when we take the vote, that it would be, however you vote, it will count for both this bill and the identical crossfile bill.
the crossfile brought before the committee yet.
Well,
Well,
but we,
it's gonna,
okay, we did have a hearing on this bill
Right, but
that is now okay. Well, I'll defer to the chair on that. making a proposal that
Okay,
one
so-
vote.
so-
I would move that we take one vote, and it does count toward, we can take a roll call as to whether the one vote will count for two votes.
Sharon, I'd like to discuss that process, because we have a lot of bills that come over from the House that are in the exact same posture as bills that we're passing over. So are we gonna say now that every time we take a vote,
No, this was a motion on this bill. This wasn't a motion on hypothetical bills.
are we not required to have even if it's a sponsor-only hearing on a piece of legislation?
Can I just clarify? We are in possession of the House bill, and as you know, most of the time, often when we have cross files that are in the same, we don't even have a hearing on our side. I mean, that's actually the rule. So that bill's in our possession. We already had a hearing on Senator Kelly's bill, so again, in most cases, we don't even have a hearing on this side. And by the way, the other chamber does the same. Half of the committees over there don't even require a bill hearing on the cross file, if it's the same cross file. So I don't know that this is that much of an anomaly.
Was the House bill on our voting list? I'm trying to find that right now.
Well, it's listed when you look at the voting list, you'll see on the right-hand corner, it denotes the fact that the cross file, the number has passed third reader. So, I mean, it's
Right.
actually physically on
And
there
it's
if you look.
physically in
But it didn't say,
possession of
it
a-
doesn't say a House bill number
Yes, it does. And it's in possession
37.
of the.
937, HB 937, in possession of the Senate Finance Committee. I think we've done this actually a lot, now that I think about it. It's no anomaly.
All right, would you just restate the motion?
Okay, the motion is that this vote, how we take the bill on, what's the number?
No.
The Kelly bill as
Oh,
amended,
890.
890, that is exactly in the same posture as cross-file HB 937, in full possession also in the Senate Finance Committee, that the vote count as a vote for both bills, both Senate Bill 890 and House Bill 937.
Okay, that's the motion. And let's call the roll.
Senator Feldman?
Aye.
Aye. Senator Klausmeyer?
Yes.
Yes. Senator Benson? Pass. Senator Kramer?
Yes.
Yes. Senator Hayes? Yes. Senator Reedy? No. Senator Augustine?
Yes.
Yes. Senator Beidle? Yes. Senator Hershey?
Quickly. If I look at the website, it says that the House bill is in possession of both the Finance Committee and the Budget and Taxation Committee. Is that accurate?
That's true.
So they're second, they don't have to, they have to vote on it, and they don't vote first on it?
No,
Okay, no.
okay.
No. Senator Jennings? No. No. Senator Benson? Madam Chair?
Yes,
Yes.
okay. So what do we have?
Is that it?
7-3.
Okay, we're not done yet.
We have one more. Hold on, okay. The other day, you sent over Senate Bill 753. This is the Cyber Warrior Diversity Program and Workforce Development for Cybersecurity. B&T was second on it. So they were second on it primarily for the fiscal note and the mandated appropriations. So after extensive discussion over in B&T particularly on the mandated appropriations and what that means for EARN and other programs, they offered an amendment to the bill to make it a 2-year sunset. So you have two choices here. If you adopt their suggestion, then the bill will sunset in 2 years, and I've made appropriate changes to some of the appropriations and the study language. Or you can reject their suggestion, and the bill would go to the floor without the concurrence of the second committee. So whatever the will of the body is, that's,
Okay. All right, we've got a motion and a second.
All in
All right,
favor?
all in favor, please raise your hand. Okay, that's unanimous. Okay, thank you.